Justice Busby, let's go back to something you started to talk about as far as just as the function of the Texas Supreme Court and about how religious liberty laws come into play and how a religious liberty case could find its way at the Texas Supreme Court. And is it possible that a case could go to the Texas Supreme Court, but then also somehow go to the U.S. Supreme Court too, that same case?
Yes, it could if it involves a federal issue, and so it depends on what law is being sued on. If you're suing on a federal constitutional right in state court, then it can come up to our court. But if the people don't agree with our ruling based on federal law, then that's an issue that can go to the U.S. Supreme Court. But if it's based on a state law, then it's final in our court. And it might help to give folks just a couple of examples of some of the kinds of religious freedom cases that we've heard over the past several years in the Texas Supreme Court. Back in 2016, we had a case called Matthews versus KOUNTZE ISD, and this is the case you may have heard about, the cheerleaders who had the banners with Bible verses on them, and the school district didn't want the cheerleaders to be able to use those banners, and so they passed a new policy saying that you can't have banners like that.
Jeff Mateer says he's heard of that case.
I may have heard of that case.
Sorry, I'm sorry, Justice Busby. You're not supposed to interrupt judges. Go ahead, Justice Busby.
I was just going to tell you what our court did with that case. That's all right. That's all right. No.
If I was in court, I promise I wouldn't do that.
And you're welcome, you know more background on it, but just to let folks know, this is one example. So religious liberty cases come up in a lot of different types. This was a particular case involving free speech rights and whether the government was doing religious viewpoint discrimination against the cheerleaders. And it came up to our court after the parents sued and the case went along for a while. The school district pulled their policy back, and so the question that came to our court was the case moot then, because the school district was no longer banning the cheerleaders from doing this. And so the case that came to our court was, okay, does that mean the parents can't sue anymore because the district changed its mind? And what our court held is no, because just voluntarily stopping something by that policy doesn't mean that the school district might not put it in place again down the road, so that the case could continue and the parents could continue their lawsuit. And it went on in the lower courts after that. And there are people on this panel that know a lot more about that because they were involved in that litigation. But that's just one example of the kind of case we hear. Another one, a case called MINISTRIES versus Higher Education Coordinating Board. This is from back in 2007. This was an Establishment Clause case, and the issue there was there was extensive state regulation of when a private college could call itself a seminary, and the private college said this is too burdensome. We ought to be able to decide if we're a seminary or not, and not have the state tell us whether we're a seminary or not. That violates our rights under the Establishment Clause, and indeed that's what our court held in that case, that was a violation. And the private college, needed to have more discretion over whether it could call itself a seminary rather than having that be heavily regulated by the state. And one last example that I mentioned the Texas Religious Freedom Restoration Act earlier, and that has to do with claims under the Free Exercise Clause, which under the U.S. Constitution has been quite diluted in its force by a series of U.S. Supreme Court decisions. You may know about Employment Division versus Smith, but the state has come back and passed a law that says for free exercise violations, a government agency may not substantially burden a person's free exercise of religion unless the government can demonstrate that it's in doing so in furtherance of a compelling government interest and that it's the least restrictive means of furthering that interest. And so this particular case, BARR versus City of SINTON, was a case that involved a zoning law, and local governments have zoning laws all the time. This particular one was that you couldn't have a halfway house, a rehabilitation facility, and helping folks that are getting out of prison. You couldn't have that in certain parts of town, and that's what this zoning ordinance said. And there was a pastor that had a religious halfway house ministry in one of those parts of town and wanted to be able to continue that, and the town said, no, you can't do that. And so the case came to our court. The pastor sued saying you're violating the Religious Freedom Restoration Act, And the case came to our court, and we held that that was indeed a violation of the act, because the policies that the city was putting out had to do mostly with violent offenders and sex offenders and that kind of thing, and those weren't the type of offenders that were served by this ministry. So just a few examples of the kinds of religious freedom cases that our courts heard over the last few years.
Well, that was great detail, and correct me if I'm wrong, I think Jeff Matier might have had a role in all 3 of those cases, or at least 2 out of 3.
Two out of 3. Kelly Shackelford.
Kelly Shackelford had a role, who is a board member of Texas Values, I might say. I had a small little role in 2 out of 3, but you know, it's not very often that religious liberty cases make their way all the way to the Texas Supreme Court, but it does give us an idea that when it comes to religious liberty at the Texas Supreme Court, there's something to cheer for. Just trying to make a little fun with the cheerleader cases. All right, just seeing if you are still awake out there. Thank our panel again, Justice Brett Busby, Jeff Matier, Eric Tree. Y'all did a great job doing that.